Hi, I'm James Minick, and today we're going to be talking about how to attack the introduction of blood evidence in the context of a North Carolina driving while impaired offense. We're really going to be focusing today in our attack on the blood in attacking basically a warrantless blood draw. So in terms of attacking the means of collection of blood evidence, there are a plethora of different attacks to keeping out blood evidence, and we are going to go through just a very few of those and really be looking specifically at a warrantless blood draw and when exceptions to the blood draw or when exceptions to the warrant requirement on a blood draw apply. When you begin any attack on a blood collection case, remind the court, point the court first of all to the Constitution. The Fourth Amendment of the United States Constitution and Article 1 of the North Carolina Constitution protect citizens against unreasonable searches and seizures. Remind your judge, based on a recent 2013 case of Missouri versus McNeely, that a warrantless search of a person is per se unreasonable unless it falls within a recognized exception to the warrant requirement. And we all know from law school that the exceptions to the warrant requirement generally kind of swallow the rule. But remind the court of that. Remind the court of the Constitution, and remind the court that if there is a warrantless search, it is deemed per se unreasonable unless the state can show that an exception applies. From 2016 U.S. Supreme Court decision of Birchfield versus North Dakota, the court said, quote, "Blood tests are significantly more intrusive than breath tests, and their reasonableness must be judged in light of the availability of the less invasive alternative of breath testing." If it is an alcohol-related case and there is breath testing available, the court basically says, yes, in the context of potentially unconscious persons, in the context of a person where drugs are suspected, those might be means where you really couldn't get a breath test. But in a case where there is breath testing available, the reasonableness, which is the touchstone of the Constitution, the reasonableness of a blood test must be judged in light of the availability of the less invasive alternative of breath testing. When an officer in an alcohol-related case for no reason goes straight to blood testing under Birchfield, this is a suspect search just from the get-go. In regards to exceptions to the warrant requirement, one exception is search incident to arrest. In Birchfield versus North Dakota, and we won't spend much time talking about this, the Supreme Court has rejected the idea that blood testing is a search incident to arrest. It is not. So if the state is arguing search incident to arrest, that blood test is a search incident to arrest, that's plainly erroneous under Birchfield. Another exception would be based on exigent circumstances. So where there are some extreme circumstances. With the DWI case, evidence of impairment is somewhat diminishing. A person is basically, at some point, once they have reached peak alcohol concentration, is eliminating alcohol from their system. And so basically there is a concern that if you aren't able to get a blood draw quickly, the evidence of alcohol is dissipating, and that is then going to cause a loss of potentially admissible evidence. In the case of Missouri versus McNeely, the court said a warrantless blood test of a drunk driving suspect must be determined on a case-by-case basis on the totality of the circumstances. The U.S. Supreme Court explained that the dissipation of alcohol alone does not create per se exigent circumstances justifying a warrantless taking of blood from a person suspected of impaired driving. So just because of the fact that this is an alcohol case with evidence dissipating, that alone does not create an exigency. North Carolina in State versus Dahlquist, as well as in State versus Granger and State versus Burris, has found situations where exigency was established. So they have looked at whether or not exigency existed in particular context, and the courts in North Carolina have found that in some contexts exigency would be found. However, the Dahlquist court pointed out a couple of things that would be important in terms of establishing whether exigency existed. One, the court asked, did the officer seek to obtain a warrant using video transmission, in terms of getting a warrant from a magistrate by video, which has been statutorily allowed since 2005. So the court said, if you can get a warrant where maybe there's not a magistrate on scene, or it would be a long way to get back and forth to the from the hospital to a magistrate, or maybe if a magistrate is not on duty, or maybe at another location, can you get a warrant using video transmission? So it would make sense then to ask if the officer has attempted anything on that front. The other thing the Dahlquist court pointed out is, did the officer call the hospital before going to a hospital, and/or a magistrate in an attempt to figure out the time it would take to draw blood and to get a warrant? So if the officer is saying, I just didn't think there would be enough time to get a warrant, and therefore I went ahead and just went straight to a blood draw under exigent circumstances, it's extremely important to determine whether or not the officer attempted to figure out how long it would take to get a warrant, how long it would take to get a blood draw conducted at the hospital. Recently, in 2017, the Supreme Court of North Carolina addressed exigent circumstances for the first time since McNeely. I don't believe there's been any other Supreme Court of North Carolina cases that had addressed McNeely ahead of Romano, and the court found the trial court aptly noted that this case did not involve a situation of exigency. In determining that no exigency existed, the Supreme Court of North Carolina noted that 1, multiple officers were present to assist in the investigation. 2, an officer could have left the hospital to drive to the magistrate's office, which was only a few miles away. 3, the charging officer was familiar with the warrant process and knew that it involved filling out fill-in-the-blank forms that are not time-consuming, which is the case with search warrants. It's a front and back form application that is presented to the magistrate. And 4, that magistrates were on duty and available during the relevant time period. So using those factors, again, base your cross-examination on those factors. Flush out those various factors that were presented by the Supreme Court as applied to your particular case. Another exception to the warrant requirement is the exception of consent. And really, in the context of a DWI case, the theory of implied consent, that a person that drives on the streets or highways is giving consent to have a breath or a blood collection occur. In 2016, again, in the U.S. Supreme Court decision of Birchfield versus North Dakota, the court pointed out that there must be a limit to the consequences to which motorists may be deemed to have consented by virtue of a decision to drive on public roads. The court went on to say that, quote, blood tests are significantly more intrusive, and again, their reasonableness must be judged in light of the availability of the less invasive alternative of a breath test. While this is still an area of law that is in the gray in terms of Birchfield being specifically applied to North Carolina, you can see a valid argument that is based on the idea that if a breath test is available, and an officer basically says, I'm going to ask you to give me a blood draw, and if you don't, I'm going to revoke your license for a period of 1 year, that seems to be a somewhat difficult position to put a person in when there's the availability to ask them to submit to a breath test. So the reasonableness of that request should be considered in terms of whether consent has been validly given. In the 2017 North Carolina Supreme Court case of State versus Romano, the court stated, quote, whether a consent to a search was in fact voluntary is a question of fact to be determined from the totality of the circumstances. Further, the state has the burden to prove that consent was in fact freely and voluntarily given. Consent is not voluntary if it is the product of duress or coercion, express or implied. A court's decision regarding whether a suspect's consent was voluntary is based on a careful scrutiny of all the surrounding circumstances and does not turn on the presence or absence of a single controlling criterion. The standard for measuring the scope of a suspect's consent under the Fourth Amendment is that of objective reasonableness. What this language, and that's the end of that quote from the North Carolina Supreme Court, what this language opens up is the question of whether somebody that has been advised of their rights under 20-16.2 is then asked to give a blood draw. Does that basically reading of the 20-16.2 rights, then asking them to submit to a blood draw alone, make that an admissible draw under the theory of implied consent? And this language from the North Carolina Supreme Court says no. Whether or not consent has been given isn't just based on the idea that there is an implied consent statute in place. You have to look at each and every case on an individual facts and circumstances determination. So implied consent, while it is a valid theory, and while implied consent laws have been upheld, whether or not a person has consented to a search of a person, in this case a blood test, is to be based on a facts and circumstances determination in that individual case. When making an attack based on the Confrontation Clause, begin with the language from the Sixth Amendment, that a defendant has the right to confront and cross-examine his accusers. In Melendez-Diaz versus Massachusetts, the U.S. Supreme Court, in an opinion issued by Justice Scalia, said, quote, forensic evidence is not uniquely immune from the risk of manipulation. In that case, there was a question about whether or not a lab report was in fact even testimonial in nature. Do you need a lab analyst to come in and talk about that? Justice Scalia noted that, quote, a forensic analyst responding to a request from a law enforcement official may feel pressure or have an incentive to alter the evidence in a manner favorable to the prosecution. Confrontation is designed to weed out not only the fraudulent analyst, but the incompetent one as well. In a case where there is a blood result, whether that's reporting an alcohol concentration or that there's drugs in your client's system, North Carolina and many other states as well have notice and demand statutes, where if the state offers notice that it intends to introduce a blood result without the certifying analyst, that the defendant then has to object to that being admitted without live testimony. If there is no objection that is offered and the notice is timely, then those lab results may come in without a violation of the Confrontation Clause, since the defendant did not object. In a situation where the defendant does object, the question is who can come in and actually testify as to the results contained in the report. What the courts have consistently said is that surrogate testimony is not allowed. That would violate the confrontation clause. In Bullcoming versus New Mexico, the Supreme Court addressed that analyst testimony in the context of a DWI, and that court said, quote, "At trial, the prosecution did not call as a witness the analyst to sign the certification. Instead, the state called another analyst who was familiar with the laboratory's testing procedure but had neither participated in nor observed the testing from Bullcoming's blood sample." In that, the U.S. Supreme Court, in that case, the U.S. Supreme Court gave the state a roadmap for what to do in the case where the original analyst is not available. The court said, quote, "The state could have avoided any confrontation clause problem by asking a new certifying analyst to retest the sample and then testify to the results of this retest rather than to the results of a test that he did not conduct or observe." And so when you get into these type of cases, and there are a couple of North Carolina specific applications where the courts have determined, is this surrogate testimony? Is this a situation where you actually have a new scientist that just analyzes what results are coming out of the machine and then issues their own report, and based on that their own report and findings then actually come in and testify? Has given some specific applications of Melendez-Diaz and Bullcoming. But again, the problem would be if the state is simply trying to offer surrogate testimony. Basically a situation where a certifying analyst looks at the report of the original scientist, looks at the labs that were conducted and how they were conducted, and basically just says, okay, here I will reiterate to you what this report says. That is not enough to satisfy a confrontation clause issue. There also may be issues with the handling of a blood sample in terms of establishing an appropriate chain of custody, where the blood went in terms of being passed from the nurse that collected the blood to the officer that is charging or acting as the chemical analyst, then being passed to a supervisor within the police force, being sent to the SBI or to another lab for testing, or going through potentially a hospital, and making sure that there is a proper chain of custody that can be established in terms of how that blood was handled. And so while that issue doesn't necessarily bring in a question of the Sixth Amendment, the Confrontation Clause, that also is important in terms of the state being able to lay a proper foundation for the handling of blood evidence.